knows case law, knows names of cases. He's extremely bright. And then you have me. So whatever the opposite of that is, that's what I am. If you're here to learn what the case law is or what the law says about demonstrative evidence, put away your notes. I'm not going to talk about it because, frankly, I don't really know what it is. What I know is that if you try and you're creative, you can find ways to demonstrate just about anything you want to in a courtroom. To me, there really isn't much of a division between what real evidence and demonstrative evidence, because every piece of evidence that comes in, I'm thinking, what's the best way to demonstrate it? And, you know, Catherine Case gave us a great idea, or a great example as she was finishing her lecture. Anytime anything's coming in, think of the best way to get the best bang for your buck. What is the best way to get across your theory and your theme, right? And if part of your theory and your theme is how important those documents are, what a wonderful way to do it. Have the person who's in charge of the documents pull out the real ones, not facsimiles, not copies, the real documents, because it gives it weight. It makes it come alive. How many people here, and I don't know who your lecturers were last week, but how many people here that think that being interesting in the courtroom is one of the most important things we do as lawyers? Okay? You all should have your hands up. Now, there may be people here who have gone to law school who think that they're really smart, and you may in fact be really smart, although my experience is most people are not nearly as smart as they think they are, particularly lawyers. But smart is not good enough. Dale Cobb, who's one of the instructors here, talks about the fact that the mind can only learn so long as the butt can endure. Right? After an hour and a half this afternoon, you know what the hell I'm talking about. Yeah, moving along. Right? The butt can endure a lot more if the butt is interested. I promise. I promise. No. You can endure a lot more if you're interested. You're going to pay attention. The greatest speaker in the world, the smartest speaker in the world, can talk for maybe 15 minutes and people start to phase off if there's not something to think about, to look at for the average juror. Now there may be the exceptional person here who can listen to an intellectual discussion for an hour and have their mind never wander to where they're going to eat tonight, or the fact that they stayed up too late in the cave last night. But that would be the exceptional person, and that's not your jury. Repeat, it's not your jury. Your jury, by and large, are visual. They have grown up on television and now internet. They don't listen to 12-hour Lincoln Douglas debates anymore. They see things in sound bites. Cokie Roberts was talking about different interviews she had done on public radio with political figures, and she was asked what the most memorable. She talked about the fact that one politician that she'd interviewed many, many times, and no matter what she asked him, it didn't matter what the question was, his answer was 11 seconds long. Didn't matter. What is the meaning of life? 11 seconds long. Because that's a soundbite. That's what we're used to. If you go back and you look at sitcoms from the 60s, you'll see one or two camera shots for the entire half hour. Now if you watch sitcoms, because of MTV effect on television, it's cutting all the time. That creates an audience that's used to visual stimulation. Now, demonstrative evidence is not just for the purpose of being interesting, but gosh darn it, we have a responsibility to be interesting. And this helps. This really helps. But it also is going to develop theory and theme. We're going to bring in pieces of evidence, and we're going to make them come alive because they're going to advance our theory, or they're going to be thematic. When Paul did his direct examination, what demonstrative evidence, maybe it's real evidence, I don't know, but what demonstrative evidence did he use that advanced his theme? What? The picture. The whole direct examination had the what's it called?
Sonogram.
Sonogram. It's been a while since I looked at those. Thank God. Unlike Paul, I have two teenage kids, and I'm really glad to be away from that. The sonogram was up there the whole time because his theme is about defense of others. Defense of the womb, defense of a baby, right? That's used thematically. Is that also real evidence? Maybe, maybe not. But it's a great theme. In a homicide case I had a couple of years ago, I had about a 2-hour opening, which I think is much longer than generally a case requires, but this one required it for various reasons. But for the last 45 minutes of the opening, there was a picture of a dog named Boots, much like Paul had in this direct examination overhead. Because a major theme in that case was the fact that my client's dog was going to save his life based on the hair evidence and things like that. So we want to be thinking about the different ways in which it's going to help us, and we also want to be keeping jurors awake. Now, some of you here are public defenders, right? And some of you are private attorneys just starting out, and some of you are private attorneys, like some of my colleagues in the back who can afford all kinds of demonstrative evidence. But every courtroom I've ever been in has something like this: a chalkboard, a dry erase board. This is demonstrative evidence. You can write anything you want on it. In your closing arguments on Friday, at the very least, you'll have these in your rooms to use for demonstrative evidence, to write a question on, to write an argument on, right? Chalkboards are great for writing down a couple of questions for the prosecutor when you sit down. A couple of questions that they have to answer in their case doesn't make sense. I just did this about 3 weeks ago. I had 4 questions that the prosecutor couldn't answer, and I just knew there were no good answers to them. And they were on a board. Now, if possible, in using this type of demonstrative evidence, you want to go in the night before, the morning, early in the morning of, or lunch break, or whatever, and write it on the back, so that all you have to do is flip it. Because I'll tell you, it takes about 20 seconds in real time to write on a chalkboard. It feels like it takes about 20 minutes when you're standing in front of a jury and they're waiting for you. So you want to try to do it ahead of time. Now keep in mind, if you flip it over, it might be upside down, so you want to think about that. You don't really want to look stupid if you don't have to. The question thing, there's something interesting about persuasion, though, and I know this from teaching negotiation. You don't do a whole laundry list when you use a chalkboard in that way. Why? Anybody? Why?
Because I think individual things will really stand out in their memory along with this one.
The laundry list, there's going to be so many things that water them down, but also think about an argument you've had with a significant other, okay? And you go through 5 different reasons why you have to watch the ball game Sunday. For a guy, maybe, if there's a guy here who does that sort of argument. 5 different reasons, and you get to the 5th one, and it's a real lame reason. What's the responding argument going to be based on? The 5th one, right? You're going to ignore the other 4. If we do the laundry list here, a good prosecutor is going to get up and say, "Are you kidding me? This is the best they have?" Address that one and turn it back around. You want to do the ones that they can't answer. If it's 1 or 2, those are the ones you nail. We all have chalkboards. Photographs. We all have photographs. Usually they come from the prosecutor. Find ways to use photographs that are interesting. You can blow them up big now. Most courtrooms, if they've had any advancement in the last 5 years, are PowerPoint capable. And I'm going to talk about PowerPoint separately in a little bit, but they're PowerPoint capable. More and more courtrooms have projectors where you can put a photograph on the projector. We've got one here that's underneath. And it shows up in 3D. A lot of them now, Elmos they call them, you can put 3-dimensional objects on them. But you want the photograph big enough to see. You want it to be used in such a way that's interesting. Drawing circles on things, writing on things. That's what we're talking about right over there. See, that was demonstrative evidence right in front of you, being used. This is a photograph in a case where a guy is accused of hoarding a whole bunch of weapons and bullets, and he's a felon in possession of a firearm, and they're afraid he's a separatist who's going to blow up across Wisconsin, as if somebody didn't care to blow up across Wisconsin. Nonetheless, that's what they want to show. And what I want to show is this guy's a pack rat. He's got hundreds of everything in this house, and the idea being, it's not about guns and weapons, it's about the fact that he doesn't ever get rid of anything he ever runs into. Charts and diagrams, very easy to use, very easy to make. We all, well, except for maybe a couple of ancient dinosaurs, again probably in the back, we're all used to using computers, right? We go through law school now, it's all computer driven. It's easy to do charts, graphs on computers. If you don't know how to do it, if you have children, I guarantee they know how to do it. If not, you can find someone that'll help you with it. Just to visualize. Something occurs differently in the brain when we see it than when we just hear about it. I don't know if you heard this last week, but as adults, we all learn in 3 different ways. We learn visually, we learn orally, we learn kinesthetically, in other words, by doing or feeling, right? The majority of people nowadays learn visually. It used to be, they speculated 100 years ago, was pretty even between visual and oral. As you can imagine, we're more and more a visual society. We want to be able to show people things. So a graph or a chart can help with something like that. And then we can do things with the graphs or charts that just talking about wouldn't have that same effect. I'll give an example. A number of years ago, I represented a fella in Wisconsin, in very rural Wisconsin, who was accused of being overly friendly with horses. And there was no question about guilt or innocence on the main charges because he was caught coming out of a barnyard with horse manure all over his front. And he was, and they sort of caught him in the act, red-handed, sort of. At any rate, the question was, is he not guilty by reason of mental disease or defect? And unlike Arizona, and I guess Texas maybe, Wisconsin has a pretty good law on mental disease and defect. However, if any of you have ever looked into the idea of having somebody with a sexual disorder, paraphilia, found not guilty by reason of mental disease or defect, it's extremely difficult. Why? Because then we would recognize that child molesters are mentally ill, not criminal. And even though we do recognize that when we want to keep them locked up for the rest of their lives, we won't recognize it on the front end, right? So you can see that to get a paraphilia as a not guilty reason is very difficult. What we did in this case is we also attached obsessive compulsive disorder, and that allowed us to at least get a jury instruction. The prosecutor's argument would be, of course, well, he made choices, he made decisions, he only went in the middle of the night when no one could watch him, so therefore it wasn't that obsessive compulsive. Well, what I wanted to show is that he dreamt about it, he would ride his the little four-wheeler around horses all the time. There are all kinds of details that would show he thought about this nonstop, but the main thing being that he was 33 at this point, and from age 16 to 33, he'd only spent a total of about 14 months out of custody because he kept doing the same thing. Now, to talk about 14 out of that many years, 14 months of that many years, I mean, that sounds, pretty amazing, right? But what we did is I brought in a calendar for each of those years and blocked off with the psychiatrist for the other side all the days he was in custody. And for each of those years, we had one large calendar, right? Blocking off. So you had all this red time that he was in prison because he couldn't help himself. And only this little splotches of white time where he was actually out of custody. And you could see the pattern. It would happen right away. Again, he needed to get help. That was a way of making it visual using charts and graphs that we could have just handled by saying he only was out for 14 months. Keep in mind how you can use your demonstrative evidence in the courtroom. When it came time for closing argument, I brought all these back out in front of the jury on stands scattered all around the courtroom, some against desks and tables. When I finished, they were all standing out there, creating this amphitheater of calendars. And then I just went and sat down. The prosecutor made the mistake of just leaving them up there for his rebuttal argument. So during his entire rebuttal, he's being framed by all these charts and diagrams. Another way of thinking about demonstrative evidence. Everything we do in a courtroom is demonstrative, right? What's the best piece of demonstrative evidence we have?
Ourselves.
Us, absolutely. Our person. Everything we say, everything we do, every place we look, every time we get up, anytime we object, the way in which we object, everything we do demonstrates something, right? That's why when we're a true believer in our case, we're demonstrating a belief in innocence. When we think we're going to get our butts handed to us, we're demonstrating concern or fear or, just trying to get through the case. Red book is an example I learned from Kathy Bennett. It's an impeachment device, and I hope I'm not stealing something from whoever's doing the impeachment lecture, but it's another way of demonstrative evidence. You've got a book that has all the transcripts, the reports that you might use for impeachment because of prior inconsistent statement or omission. And when you have witnesses, and you have a witness up there, and the first time they're going to say, no, I said something different, or I didn't mean that, and you got to catch them on it, right? And you do it a second time, or the third time. If you say, didn't you say this, on a certain date, they're just like, yeah, right, whatever you say. If you say I said it, then I said it. Well, imagine every time that happens, you leave the podium, you walk over to your table, and you pick up a bright red binder. And you slowly walk back to the podium, as if this is the word from on high, right? And you put it down, and you click it open with a loud noise, mind you. Click, you pull out the transcript, and then you begin your impeachment. When you're done, you put it back in, you close it. You put it back down, right? This is the holy book. By the second or third time, all you have to do, I swear because I've done it and it works, is go like this. They say, all right. Beautiful. Demonstrative evidence. PowerPoint. How many people have used PowerPoint in the courtroom? Okay, I have. It can be great. It can also fail on you. My computer crashed last night. It's up till 2 in the morning trying to kind of rearrange things to get this done. But it can be overused. We are a society now who's very used to PowerPoint, right? We're used to seeing lectures on it, particularly professionals in our society. It can be overdone. PowerPoint is a way of objectifying, of taking us away from the material. If you're not careful, it can become about that instead of this, or if this is a client, instead of this, right? We don't want to become about PowerPoint. We can use it, though, for demonstrative purposes. Absolutely, it can be very powerful. When you have to teach a jury about something, it's a great tool. I had an accident reconstruction expert about 1.5 years ago on a vehicular homicide case, and the question was who was driving. And my guy survived, another guy didn't survive. We were saying the other guy was driving. Competing experts. My expert had a 40-slide PowerPoint presentation that was wonderful. It was like a really interesting professor teaching a class. The way that we kept this in the moment, kept it connected to the case, is that he was standing over here with the projector going through the PowerPoint. I was constantly reinterpreting what he was saying, trying to understand it. I'm not an engineering person. It was easy for me to act ignorant. I was. So I would ask him questions that I thought were clarifying with a little Tonka truck, which was modeled like the truck that was in the accident, on the jury rail. So every time he would describe something here, I would just say, what you're talking about, is it doing this? So we've also got an interaction going on between the jury and myself and him and the jury. And there were times where I could see puzzled looks on jurors' faces, and I could just jump right in. Very effective. There's no question in my mind that we won that case because of that expert using PowerPoint effectively. This is a fellow by the name of Jerzy Kotowski. He was a theater philosopher in the 1940s. He led a revolution in theater that said that theater is not about costumes, it's not about scenery, it's not about grand musicals. Theater is about actors in a space communicating. And what he wrote about is towards the fourth theater. The idea being all you need for theater are two people talking. And they can create a relationship, they can create a space. That's theater. Anything else is window dressing. What does that tell us? We can do the same thing in a courtroom. This is our space. The courtroom is our space. We can make it anything we want. We can do anything we want with ourselves in a courtroom. We can use our clients. We can use the door of a courtroom. I've shut off the lights in the closing argument to show how somebody could not have seen the color of a jacket as to whether it was dark brown or black. Right? We can use everything we want. Let me give you an example. A sexual assault case last fall. Issue by the time we got to trial was consent. At the time of the arrest, it was mistaken ID. You know how that happens. DNA comes in, now it's consent. At any rate, opening statement, I set up the bedroom where the consensual sex took place. Doorway's here. You walk in, I would take my time in opening. You walk in, you'll see a panel of windows. There's windows along that side, windows on that side as well. It's an add-on room, in case you worked on actually this spring, and also Kathy Kelly in Wisconsin. It's an add-on room. The bed, if you walked in and stood over here, the bed would be back against this wall, up against the wall, and up against that wall. So there's no room on the side of the bed or the head of the bed. At the foot, there's about this much room, and you'll see in the pictures that it's full of clothes and a gym bag and things like that. Part of the defense is the fact that the client was let into the bedroom by the woman. He got in the bed, she got in the bed after him, they had sex in the bed. What her version is, she woke up in the middle of the night on a single bed against the wall on either side with my client having sex with her from behind, vaginal sex from behind. Part of our argument is that there's no way he could have climbed onto that bed. He's taller than I am, he's about 6'4". Climbed onto that bed, got her pants off in the way that she's described, had sex with her without her waking up or falling off the bed. But the reason the space is important is I set this up in the opening, and then when she testifies, I bring that all together again. So I ask her questions. Ma'am, I'm going to ask you some, you're going to be here for a second. I'm going to ask you some questions about your bedroom, all right?
Okay.
If we were to imagine that the kitchen is back over here, this is the hallway leading to your bedroom. You with me?
Yes.
And this is the entrance to your bedroom.
Okay.
As we walk in, there would be windows along here, correct?
Right.
And there's windows on that side?
Right.
And there's windows along this side as well,
Yeah.
right? Your bed is over in this corner.
Yeah.
And there's a little space between your bed and sort of the wall where the door is, right?
That's right.
About this big.
Uh-huh.
So if we were to step in here, it would be about like this between the bed and the wall.
Yeah.
But on that night, we wouldn't be able to step there, right?
Right.
Because there was a pile of clothes there,
Yeah,
There
there
was
was.
a bag or something.
Uh-huh.
I don't remember all of it. A purse maybe. So there's a bunch of stuff there, right?
Uh-huh, my gym bag.
Gym bag. What we're doing is we're creating a visual space. Did it in the opening, reinforced it in the cross, reinforced it yet again in my direct examination. Demonstrative evidence is in part about reinforcing the story you've told in your opening by bringing out information. I promise you, as Kathy said, this stuff is not in a transcript. And a appellate attorney who looks at this is going to go nuts. I mean, what the hell are you talking about? It's over here, it's over there. What does that tell me? Nothing. Probably that's true. But there's no way in hell I'm going to stop here and just say, let the record reflect I'm showing 1 foot. Let the record reflect I'm showing 6 feet. Because what I want to do is bring the jury with me, right? By demonstrating what happened. And I promise you it works. And I know it works because when a prosecutor gets up to do redirect, they will use the same rule. It happened every time. Prosecutor gets up, all right, ma'am, let me ask you a couple questions. Did you allow him to get on your bed? Now he's in that room. When I was in, I swear to God, you've tried this now. Does it work?
It does.
It works. That's what happens. Now, one rule of improv. When you create a scene, you don't destroy it. For the rest of that trial, I walk around that bedroom, walk around that bed, right, when I'm talking to the jury. You're reinforcing it every time. If you walk through it, it's no longer real. You've got to keep it real. If someone else should ever do that to you, the very first thing you want to do is just get up and do something like this. Let's start over. Let's imagine the bedroom door is right here. I swear to God, that's what you want to do. Just don't tell a prosecutor. All right, I'm going to show you, just briefly, a way of using PowerPoint in a cross-examination. I'm going to sort of breeze through this. This is one I actually put together for Advanced Cross last fall. Freddie Oates, if you remember the name, he's got a lot of aliases. So we're going to look at how you might use different convictions under an alias and how you might use photographs. Freddie Oates is a snitch in this case. We all have snitch cases, right? Freddie Oates is a snitch in this case. We're going to cross-examine him. This is a shot of him doing a bank robbery on March 3rd, 2006. So we might start the cross with a picture of him on the camera they got to show, number one, they got him dead to rights. Number two, we're going to show a prison that he's been to previously. We're going to bring in the fact he's been in prison, he knows what prison's about. At this point, that chapter in the cross-examination using this demonstrative piece is about a day in the life of prison. Okay? And again, then you're going to be demonstrating maybe the size of the cell, things of that nature. Next, we're going to talk about what led him to prison that first time, and that was this conviction, again for armed robbery, back on October 22, 1998. Then we're going to then show his record as Frederick Oates. Got a nice little released smile there because he likes to be released. Assuming that you can get in all this stuff. We then also know that under Frank Oates, he's got a separate record. Under Frank Yates, he had another record. And under Freddie Yates, we've got this. And Frederick James, we've got this. And Frank Burns, we've got the one that, the 2 armed robberies, one that was reduced to a theft, and then the one that he's got now that he's facing charges on that he's trying to work off, right? So we got the smiley faces again, showing that's what it leads to. And then we get to see all of them put together. This is rudimentary PowerPoint. Anybody here can do this, I promise you. It's extremely simple. If you can't, you just have somebody work with you because this took about 10 minutes, right? It's easy to do, it creates an effect. It's demonstrative evidence. We then look at a jail log. Timelines are great on PowerPoint. That's another great tool for PowerPoint. March 3rd, he was arrested and brought in. March 8th, met with his attorney for 7 minutes. March 25th, he had a full 10 minutes with his attorney that day. Now, but let's look at the jail log on April 12th, the day before our trial. This cross-examination is taking place on April 13th, right? On April 12th, we've got a visit from his attorney, a longer one than he's ever had before by at least 3.5 times. And we've got a visit from the prosecutor in this case. Now, isn't that interesting? Now, have you all heard about in-court identifications of prosecutors? Some of you, not everybody. All right, this is another way to use demonstrative evidence and spatial relationships. In any case where you've got bad guys, and the prosecutor has to call the bad guys as witnesses, you want to create space. This is prosecutor space. No. I'm sorry to ask you this. I don't know you, but would you be a prosecutor for a few minutes? All right. This is a prosecutor, right? Got a witness over here. I'm asking the witnesses questions. I say, now, for 235, you got a visit from someone else. Who was it? It was prosecutor, right? It's prosecutor. Let me ask you something. The prosecutor just mentioned. Is he in this courtroom? Would you mind pointing to him and tell me something he's wearing? Your Honor, I'd like the record to reflect that he's identified the prosecutor in that terrible suit over there. Right? Again, you create spatial relationships. And the cross-examination I'm going to do of Freddie Yates, I'm going to tie it probably in his space. I'm going to get right in his space every chance I get. Beautiful thing will happen. You walk up behind a prosecutor while you're doing a cross-examination of somebody associated with them, and you stand behind them. What do you think they do? What? They start going like this. They cover up their notes. They're writing all this really important stuff they don't want you to read, so they start making these furtive gestures right there in the courtroom. It's wonderful. So then the attorney comes back, this time for 13 minutes. Now, if we just did cross-examination without some sort of demonstrative aid, it just doesn't come true as much as it does on something, and I'm telling you, this is so simple. But you could do the same thing on there, right? You could do the same thing on there. They also have this beautiful thing now that you can do the night before. They have giant sticky notes. Have you ever seen those? They're like this big, and just like the little sticky notes, except they're giant size. You peel them off, you can stick them up anywhere. So you can prepare anything you want the night before. And this is where he was before he came to testify today. And that's where he's been since the arrest. That's what he's going to try to get out. That's a picture of the current jail he's in. A very simple use of PowerPoint. Now, for those of you that want to get a little bit more elaborate, I'm a big fan of use of models in the courtroom, both small scale and life size. This is a case I consulted on a number of years ago. It was a civil rights trial. This fellow was put in isolation in a county jail for 67 days because he was mentally ill, and they didn't want to pay for a psychiatrist or medication. And so it was cheaper to do it that way until the court found him incompetent, then the state had to pay for it instead of the county. That went to trial, and the jury found that the county was liable, but they only gave this guy $2. So that's all that 67 days was worth, was $2. For a lot of reasons that I don't really want to go into now, was overturned, and liability was established in this guy, who actually now is my law partner, but at the time wasn't, asked me to come and work on the case. That was not used in the first case, and what I realized right away is that the jury never really had a sense of what it meant for him to be in isolation for 67 days. The first thing I wanted to do was actually build a jail cell. I wanted the jury to have a sense what that man would look like in that small space and what he did all day. I spent a day with him talking to him about what it was like being there. Going back with him to retrieve those memories. What are you seeing? What are you feeling? All that sort of thing, minute by minute through a day, so we could see what it was like. We built this up. Federal judge let us in. This is in a federal courtroom. He testified for about 20 minutes from inside the jail cell, sitting on the floor, talking about the different things he thought about and did. The jurors, as you can see, they were feet away from him, leaned over and wrapped attention the entire time, and it looked as if they weren't breathing for the entire 20 minutes. I've never seen anything like it. Because that allowed them to be in that place with him, as him. Because what I found through doing mock juries on this is that people said, 67 days, 50,000, I'd sit in there. And I wanted 500,000 per year. And that's what I thought he should get for this. And they were like, no way. I would do it for that much. So what we needed was to understand how he felt in that space, not how they would feel. Him with his mental illness, his paranoid schizophrenia. And it created PTSD on top of it. And it worked. The jury came back with a $5.4 million verdict the second time. In large part, I think, because of this model. Two things. This model cost about $900 in materials. Right? We all bring in experts. I think even public defenders in most parts of the state can bring in experts that cost more than that. This was worth much more to us than the psychiatric expert we brought in, who cost us $10,000. this was invaluable, $1,000. Labor would have been donated if we had lost by a local theater department. That's where you go for this stuff. For them, this is easy. I mean, for me, I couldn't do that to save my life, but it was to the specifications of that jail cell. They do this all the time. It's easy for them to create models. So they put that together for us. Now, how do you get it in? You get it in by trying to figure out what's worse than this, right? So we filed a motion asking the judge to allow us to do a jury view at this actual jail, which was 2.5 hours north of the Madison courthouse. And the judge was like, no way. But in the motion, we said, if you won't let us do a jury view, at least let us do a model, a scale model. Well, everybody assumes scale model meant, tabletop. Scale model. She said, fine, you can have your scale model. Came in. I also had a case with a guy accused of attempted sexual assault of a boy in a bathroom at a campground. I went to look at the stalls. There's no way he could have slid under the way the guy said it was impossible. The stalls were too low. I had a local theater person build the stall out of styrofoam, right? But to the specifications. Again, full size, brought it in. Invited the jury to ask the judge if they could look at it once they went back to deliberate. Of course they did. They came out and they found him not guilty right after that. Tabletop models can show diagrams, houses. And what they can do with a theater model is that they can magnetize it. So you can actually stand it up in front of the jury on an angle and move pieces around that are magnetized to the model. Just fantastic stuff. But the only thing we're limited by in the courtroom is creativity. Constantly look at what's a way that I can make something come alive, I can demonstrate something to make a point that I really can't make another way. A homicide case I had 2 years ago, A&E did a documentary about it called Facing Life, the Retrial of Evan Zimmerman. And in that case, my client was accused of killing a woman who was an ex-MP. She was 180 pounds, strong, mean. My guy was about 140 pounds, extremely out of shape, alcoholic, severe alcoholic. He was accused of killing her on a night where he was at a bar. So drunk, the bartender said he had to lean against the wall to hold himself up on the way out of the door. He assumed he would find Evan passed out in his van. He was accused of killing her in his van and then dragging her body across town and dumping it somewhere. And I knew that was impossible. There's no possible way he could have done that. So we got a 180-pound rescue dummy that I wanted to bring into court to show, let the jury just hold this and see how impossible, I don't mean this as a ton, this is literal, how impossible dead weight is to carry, right? 180 pounds. This is actually like 165 pounds. She was 180. I'm going to show you how well they worked. It was fabulous.
Thompson and managed not to leave one piece of direct evidence.
Because I came carrying by myself. So for this hearing, I brought in this firefighter's training dummy called Rescue Randy. Fire departments use it to simulate what it's like to carry around a real person.
We have to bring it up there so the judge can see it and we can get it into evidence.
God, this is brilliant.
So
This is fantastic.
You know, this whole situation is so serious. But that dummy, it was ridiculous.
Oh my God, I can't believe how heavy this is.
And it was only 120 pounds, not 180, and nearly impossible for two lawyers to pick up.
I was thinking maybe we should just...
Which may say as much about us as it does about the doll.
well, you call it.
Let's see if we can pick
It's dead weight.
just see if it's the same. Oh my God.
Eventually, we realized we're just going to have to tell the judge about it.
All right, let's throw him back in. Okay, I'm sorry, Randy.
It's pretty tough one.
All right, so.
Is that the A&E show?
Yeah, that's the documentary. We got the dummy up. We didn't bring the dummy up. We left the dummy there. I invited the judge to come down and see it. The DA did not object to it coming in, which I thought was fantastic. The judge on his own kept it up. It's a discretionary decision. He said it couldn't really match what a 180-pound body would have been like that night for Evan Zimmerman, so they couldn't even feel the weight of it. We had done a lot of research about it. We did a lot of research after that. This was a pre-trial motion. I believe that this was really huge. I really wanted to get this in. I thought if a juror tries to pick that up, they'll acquit in that moment. Because there's no way that man could have possibly lifted up that or picked up a body of that weight. And again, it was only 120 on it. So I spent until the second day of trial thinking, how the heck are we going to demonstrate in some real way how impossible this would have been? We have to show this man could not have picked up a 180-pound body. We had a bartender come in to testify. It was Evan's bartender. The prosecutor had to call a bartender because he was the last person to see Evan before he left the bar. The bartender is the one that says he had to lean against the door. Now, you're going to see part of that cross-examination in a second, but what you're not going to see is another way we used demonstrative evidence. My theory was that and she had been arrested the night of her wedding. She got married to another man. He and her both got arrested for getting in a fight. I mean, the whole thing is just really tragic. She's allowed to leave at 2 in the morning. The new husband is kept overnight because he's got a probation hold. We let her leave the jail at 2 in the morning. She has to walk through a neighborhood with about 13 different bars. Some of them pretty dangerous in Eau Claire. So we've got a bartender up there. We take on PowerPoint, and thank God my guy's son is a computer guy because I could not have done this one. We take the bartender through each of the bars on PowerPoint as an expert witness on the bars of La Crosse, right? So now we've got this guy up there not only demonstrating all the different places she went, but also testifying about what kind of crowds they have in there, which ones are more dangerous, which ones are likely to be selling drinks out of the back door after midnight or after closing time, things of that nature. But I want to show you one other piece of work. There you go. Yeah, you can go there.
Mr. Jensen, let me just start where you ended with Mr. White.
This is bartender.
Evan was pretty drunk that night.
I would say yes.
That's an understatement, isn't it?
Yes, it was. He had to use the wall for assistance.
Okay.
I got to tell you, there was a rule in this courtroom you had
Evan
to
was
sit
an
down for
alcoholic
witness
at that time?
examinations. Otherwise,
Yes.
And he also had back problems too, correct?
Yes, he did.
Now, you actually were able to observe him lift things.
Yes, I was.
Specifically, when he would work for you, he'd have to try to lift bar stools up into a bar.
Yes, he would.
And he was having a hard time, wasn't he?
He couldn't get the second stool up without sitting down and taking a break.
And you, in fact, have weighed those bar stools, haven't you?
I was asked to weigh the bar stools, yes.
And how much do they weigh?
15.4 pounds.
Now, at this point, I'd like to introduce that into evidence.
Ever since we lost that dummy at that pre-trial hearing, I've been trying to find some way to demonstrate in front of the jury how impossible this would have been for Evan to do.
I'm showing you what has just been marked exhibit number 334.
This is the bar stool that Evan Zimmerman couldn't pick up with 2 hands. The same guy who's accused of killing a woman, much larger than he is.
I watched him pick the first one up, and the second one, he put it up there and he sat down. He was winded.
15.4 pounds.
15.4 pounds.
Thank you. Have no other questions? I would move for admission into evidence the bar stool.
I have no objection.
So, what's the lesson there? I just wouldn't give up. There had to be some way to demonstrate that. Now, the bar stool, is that real evidence? I mean, who knows? And that's not the reason I brought it in. I brought it in to demonstrate that this guy could not lift 180 pounds. There's no way, it just wasn't going to happen. And it came in. 2 side notes. Number 1, Evan was found the case was dismissed, actually. It was set for 2 weeks. And this was a retrial on an Innocence Project case. He had spent 3.5 years in prison. And first week into a 2-week trial, the prosecution dismissed it and said they didn't have a case anymore.
And what did the jurors say?
Kathy asked what the jurors said. The jurors, there had been 40 prosecution witnesses who had been called up to that point. We were going to start our side of the case on Monday. He told us Thursday night he was going to dismiss. The jurors, when asked by reporters what they thought, they said we didn't understand why only the defense got to call witnesses in the case and not the prosecution. That was the quote in the paper. And I'll tell you, quite frankly, I haven't had a chance to pay this debt of gratitude since that trial. But I owe a lot of the reason they thought that to this man over here, Steve Wrench, who, I don't know, maybe 13 years ago when I was a student, explained to me how you did storytelling cross-examination for the first time. And that's what this case was all about, was storytelling cross-examination. But the other thing I wanted to tell you saw this sort of beady-eyed looking guy there that was sitting at the table? Any guess who that was? Prosecutor, right, of course. My kid saw this, he said, Dad, it looks like Ichabod Crane. The prosecutors, he was a famous guy. I'm going to tell you how famous he was. He was so famous, he was on David Letterman, not because of this case, way before this case. His name is Rich White. When he was first running for DA, he ran as a Republican, so his sign said, Rich White Republican. That's it, thanks.